Okay, sellers, let's talk about what makes a lot of you nervous. The Ohio Residential Property Disclosure Form. I know this form causes a lot of anxiety. A lot of sellers approach it with uncertainty. What exactly do I have to disclose? What happens if I get it wrong? What if I forget something? What if the buyer uses the disclosure against me? Those are all legitimate concerns, and that's exactly why we're going over them today. Because in Ohio, this form is a legal document, and how you complete it does have real consequences for your transaction. So let's demystify this. Let's walk you through what you actually have to disclose, and I'm going to show you why being thorough and honest on this form actually protects you instead of hurts you. First, let me explain what this form actually is. The Ohio Residential Property Disclosure Form is a state-required document that sellers of residential real estate must provide buyers. It's required by Ohio law. The form was updated and the current version became effective in June of 2022. The purpose is straightforward. It gives buyers a statement of certain conditions and information about your property that you actually know. And that's the key phrase right there, actually know. Ohio law requires you to disclose what you know. It does not require you to investigate or discover things that you do not know. You don't have to hire inspectors to look in places that you can't access. You don't have to investigate areas of your home that you haven't been in years. You disclose what you actually know from living in the property and owning the home. And that's it. Here's another thing that might make you feel better. The form states clearly that it's not a warranty of any kind by the owner or by the agent. It's also not a substitute for a professional inspection. Buyers are encouraged to get their own professional inspection, regardless of what your disclosure says. So you're not guaranteeing anything. You're just being truthful about what you know. Now let's talk about the consequences of not disclosing. This is important. While the form is not a warranty, Ohio law does hold sellers accountable for misrepresentation, concealment, or non-disclosure of information required to be disclosed. If you know about a material issue and you fail to disclose it, you could face legal liability after the sale. That's the risk. That's why being honest on this form is not optional. It's how you protect yourself legally. Okay, so the form has to be provided to the buyers before they sign the purchase agreement. If you don't provide it before the contract is signed, the buyer has the right to rescind the contract. So you want to get this done early. You want to complete this thoroughly before your home even goes on the market. This isn't something that you want to rush through the night before an offer. Now let's go through what the form consists of section by section. This form is 5 pages long and it covers a lot of ground. Let me walk you through the key sections and explain what each one is asking and what you need to think about. Section A is water supply. This is asking where your water comes from. Public water service, private well, or shared well. For most homes in Summit County and in Cuyahoga Falls, it's public water. If that's you and you do not have any issues, this section's pretty straightforward. You check public water, you say no to problems, done. But if you have a private well and have ever had water quality issues, those need to be disclosed. Section B is sewer system, same idea. Public sewer, private sewer, septic tank. For most of us in this area, it's public sewer through the city system. If it's anything else, or if you've ever had sewer backups or leaks, you need to disclose it here with details. Section C is the roof. And this one is one I see constantly come up in real estate transactions. The form asks if you've ever had any leaks or problems with the roof or gutters. The answer is yes, and even if the problems have been fixed years ago, you still need to disclose them. This is where a lot of sellers get stuck. They think, well, we fixed it, so we really don't need to mention it. Yes, you do. And here's the thing. Disclosing a repaired roof issue actually works in your favor. Here's why. If you say, I had a leak on my roof in 2021 and I had it professionally repaired by XYZ Roofing in March 2021, what you're telling the buyer is that you identified the issue it was taken seriously, and you had it professionally fixed. That builds confidence. That's way different from buyers discovering evidence of a roof repair through the inspection with no prior documentation of any repair. That discovery creates doubt. Transparency creates confidence. Section D is water intrusion. This is the big one. This section asks about water leakage, water accumulation, excess moisture, anything regarding water damage or flooding, moisture seepage, moisture condensation, ice damming, sewer overflow, leaking pipes or appliances. There's also a question about whether the property has been inspected for mold or not. In Summit County, we see this section come up all the time. Our older housing stock and climate mean basement moisture is common. And this is where sellers really need to think carefully and honestly. If you've had any water in your basement, any moisture, any signs of moisture, any mold remediation done, those need to be disclosed. And again, I'm going to tell you the same thing. Disclosing this with repairs actually documented works in your favor. If water entered your basement in the past and you had it professionally waterproofed, you say this: previous water intrusion in basement waterproof by XYC Waterproofing, February 2022. You're telling the buyer the problem existed, you took it seriously and had it addressed. That's very different than a buyer discovering that there's been prior water damage through the inspection and it hadn't been disclosed by the seller. Section E covers structural components: foundation, basement, crawl space, floors, exterior and interior walls. It asks if you know of any movement, shifting, deterioration, material cracks, settling, or other problems. If you've had foundation work, structural repairs, or significant settling issues, those get disclosed here. Minor cosmetic surface cracks don't necessarily need disclosed, but material structural concerns do. Section F is about wood destroying insects and termites. If your home has ever been treated for or had signs of wood destroying insects or termites, then disclose it. A past treatment that has resolved the issue is still a disclosure item. Section G covers mechanical systems. This is a big one. Electrical, plumbing, heating and cooling, sump pump, fireplace, chimney, lawn sprinkler, water softener, security system, central vacuum, built-in appliances. For each system, you list yes, no, or not applicable. If any answer is yes, you describe the issue and note any repairs that were completed in the last 5 years. This section rewards honesty and being specific. Buyers will have the home inspected. Inspectors will evaluate all of these systems. Disclosing known issues rather than hoping that they don't get discovered is almost always the better approach, both legally and practically. Section H is hazardous materials. Lead-based paint, asbestos, radon gas, other toxic substances. For older homes in Summit County, this section does require careful thought. Homes built before 1978 may have lead-based paint. Homes of various ages may have asbestos. Radon is a naturally occurring gas that can accumulate in homes. If you have ever had any of these identified, tested, or remediated, you'll want to disclose it here. There are also sections on underground storage tanks, underground wells, floodplains, Lake Erie coastal erosion, drainage erosion, zoning code violations, assessments, homeowners association, boundary issues, and encroachments. And there's a final catch-all section for any other material known defects. The bottom line across all of these sections is this: you disclose what you know. You provide details, you document repairs, and you don't try to hide things hoping that the buyer won't find out. Now let me address some of the common questions that sellers have. First question, do I have to disclose issues that repairs already have been done on? The answer is yes in most cases. The form specifically asks about previous or current conditions. A repaired condition generally still needs to be disclosed, with a description of what the issue was and what was done to fix it. And I'm going to repeat this because it's important. Documenting the repair alongside the disclosure usually works in your favor and not against you. A buyer who sees that a known issue was professionally repaired has more confidence in a home than a buyer who discovers a past issue in their inspection with no prior disclosure. Second question, what if I'm not sure if something qualifies as a material defect? My answer is simple. When in doubt, disclose it. The legal and practical risks of not disclosing a known defect are almost always greater than the risk of over-disclosing. If you're genuinely uncertain about a specific situation, consult a qualified real estate attorney. Third question, what if something happened before I even owned the property? You disclose what you actually know. If you know that the previous owner had a roof leak or a foundation repair, and if that information is within your actual knowledge, it should be disclosed. If you have no knowledge of prior issues, then you indicate no knowledge where appropriate. Fourth question, do I need to disclose things that happened more than 5 years ago? The form asks you to describe repairs completed in the last 5 years. However, the obligation to disclose known defects is not necessarily limited to 5 years. Significant known issues should generally be disclosed, regardless of when they occurred. If you're unsure, consult a qualified attorney. Okay, so you've completed the form. So what happens next? You sign it as the owner. You provide it to potential buyers before you enter into a potential purchase contract. The buyer and their agent review it. The buyer signs acknowledging receipt. But their signature doesn't mean that they approve of any condition. It just means that they received and reviewed the form. Buyers use this information to inform their inspection decisions, their offer strategy, and their due diligence. So you've set the stage, you've been transparent, now they're making an informed decision. And here's what I want you to understand about the whole process. Completing the form honestly and thoroughly does not mean you're inviting buyers to back out. It means that you are giving them accurate information so that they can make an informed decision. That transparency is better for everyone, and it protects you legally as well. Think about it from the buyer's perspective. Would you rather buy a home from someone that was upfront about known issues, or someone you discovered had issues but they never mentioned it? The upfront person has credibility. The person who hid things loses credibility, and you're vulnerable to legal claims. The best case scenario is this. You've had an issue, you had it professionally repaired, you disclose it with documentation. The buyer sees that you are a responsible owner who takes care of their problems. They see professional work has been done, they feel confident in their purchase, and everyone wins. At the Realize team, this is one of the first things that we walk our sellers through before we list. We help you understand what each section is asking. We help you think through about what you know about your own property. We help you approach the form in a way that's thorough and honest, without creating unnecessary anxiety. We also help you think strategically about what the form might reveal and how to address known issues before listing versus leaving them for the inspection negotiation. The bottom line is the Ohio Residential Property Disclosure Form is one of the most important documents in a real estate transaction, and one that you benefit from taking seriously and completing carefully. The goal is not to scare buyers away. The goal is to give them accurate information so they can make an informed decision. Sellers who approach this form with honesty and thoroughness consistently have smoother transactions than those who try to minimize or avoid disclosing known issues. And when you've had issues addressed professionally, documenting those repairs alongside disclosing them is one of the best things you can do. When both sides of the transaction have accurate information, the process works better for everyone. You close faster, you have fewer surprises, you have less conflict, and you have a better experience overall. If you're thinking about selling in Summit County and want to understand the seller process and what comes next, we'd love to help. Reach out to the Realize team and let's walk through your disclosure form together before you list your home. Are you planning to sell soon? Have questions about what you need to disclose? Drop them in the comments or send us a message, because we walk every seller through this before they list. Follow us for more from your family in real estate. Love you. Bye.